Palisade Trolley is arguing that it's offering trolley service, and that's different from motor vehicle service, and therefore it's the only entity that could have met demand for trolley service. Finally, Palisade Trolley argues that the Commission should reconsider the weight given to certain letters of support that were filed in and admitted into the evidentiary record in this proceeding. Last week, as I mentioned, the Commission took up a number of procedural questions, but tabled the issue or tabled the proceeding in order to gain a better understanding of the doctrine of regulated monopoly and how and whether that applies to this proceeding and how to apply it to these facts. And so with that, Chair, I'll turn it back over to you because I think that's where we left off last week.
Thanks, Mr. Acera. That was very helpful in framing the discussion. And I guess for me, I'd like to explore with you guys about potentially changing the standard, or at least adopting the standard. And I don't think we necessarily need a statutory change to adopt the standard. And here's what the statute says in Title 40-10.1-203. The Commission has the power to issue a certificate to a common carrier and may attach to the exercise of the rights granted by the certificate such terms and condition as, in the Commission's judgment, the public convenience and necessity may require. So for me, the statute provides a broad delegation of power to the Commission to exercise judgment and says nothing about the regulated monopoly doctrine. In contrast, in the section which immediately follows, the statute goes on to talk about taxi cab service with and between counties with a population of less than 70,000. And I'm quoting the statute. The granting of a certificate to operate a taxi cab service within and between counties with a population of less than 70,000, based on the most recent available federal census figures, is governed by the doctrine of regulated monopoly. So the legislature, in certain situations like taxi cab service, clearly determined that the doctrine of regulated monopoly applies, but did not make a similar determination in regulating common carriers, and in fact has explicitly given us wide discretion to exercise judgment. I know that there's a line of Colorado Supreme Court cases that largely at our request and based on our findings that conditions of natural monopoly existed, adopt and apply the doctrine of regulated monopoly to common carriers. But when I read those cases, the Colorado court has generally, but not always, deferred to our expertise as the economic regulator and our view of the public interest. You know, given these cases, I believe there's some room to adopt the legal standard in a way that would have, at least in my view, a good chance of winning on any potential appeal, given the deference that we've been granted by the courts in this area. So for purposes of these cases involving sightseeing services, you know, at least for discussion purposes, you know, I'd like to explore whether we should include an additional upfront test to the legal analysis after the operator fitness test, but before we apply the regulated monopoly doctrine. And this test would ask whether the market that the service provider seeks to enter exhibits the characteristics of natural monopoly. This analysis might involve two parts. First, does that market involve an essential service like critical transportation, electric or gas? And second, would the public interest be potentially harmed by enhanced competition in the market for that essential service because of structural reasons such as limited customer demand? If the answer to either of these questions is no, then I don't think we should be applying the regulated monopoly doctrine, as the market doesn't exhibit the characteristics of natural monopoly. And here in this case, I think the answer to both those questions is clearly no, as it's tough to argue that sightseeing is an essential service and that this market just seems far too broad to be a natural monopoly constrained by limited demand. So, you know, in this case, I clarify that, you know, at least for this discussion, that we're adding into the legal standard an additional test to determine if the market in which the services are provided exhibits the characteristics of a natural monopoly. If yes, then we apply the regulated monopoly doctrine, but then no, but if not, then we wouldn't. And I get that in many ways, this is a legal question, but I'm just really struggling to continue signing orders that apply the regulated monopoly doctrine to markets like sightseeing services that to me are just clearly not natural monopolies. So, I mean, it's the Supreme Court decisions. I mean, they're from 60 years ago, constrain us, but I don't think the statutory language concerns us. So with that, I'll just stop and see what you're thinking, Commissioner Gilman, then I'll turn it over to you, Commissioner Gavin, and see where to go. Commissioner Gilman.
Yeah, thanks. So one of the things that's, I guess I'll say up front, I may benefit from conferring with legal counsel before we finish this, just given kind of the discussion.
And one thing on that, and subject to Commissioner Gavin's willingness, we may want to punt this another week, so we really can confer with counsel. And
I just want to give you a heads up before my comments. I think that would benefit me. But one thing, one thing that is actually confusing in this proceeding as well as some others, it's my understanding, and Mr. Sarah, correct me if I'm wrong, that their application for common carrier includes charter, shuttle, and sightseeing service. So sightseeing is one facet, and I think that's the area we've struggled the most to be like, how do you ever prove a need to sightsee, or there's a really high hurdle there that I've made the argument before, I think might be unrealistic in nearly every case. But this one actually has 3 different services all wound up in it, and I find it fairly confusing, just in all honesty, within the record of this proceeding to decipher seats, intended for this service versus that service when we're talking about 3 services, especially when we're talking about the interveners, and all the calculations that were done about seat availability. If you're talking about something like a charter, open seat availability means almost nothing because you have to book the entire vehicle. And so it becomes very difficult in these records to even decipher what the direct comparison to be made is, which, I think kind of reinforces that this is a very difficult way to be regulating these services. But I did just want to point out, since you just mentioned sightseeing, that technically, as I understand this application, spans some other common carrier designations as well.
Fair enough. Any thoughts on the broader point and which direction you'd like to go with that clarification, which I agree with and totally fair. I'm just trying to simplify.
So would your suggestion would be to do that in this proceeding rather than try to investigate that in a rulemaking separate and apart from determinations of fact within this particular proceeding?
Yeah, that's where I'm at. I think this whole area has developed organically through, case law. And I think it's not inappropriate to start trying to change it through case law. But, that's where I'm at. I'm not sure counsel agrees, and you may need some time to work with counsel. I
mean, that's a helpful clarification. But yeah, I think it would be important for me, in all honesty, to just go back and look at the case law and try to understand, as I talked about, these different types of common carrier, and is there any leeway there?
Commissioner Gavin.
Well, I think we really need to segregate these 2 issues. I think the instant proceeding we have in front of us needs a decision today, and I would like to move toward that. And then I would like to work with counsel to get more color on, the legal ramifications of doing what you say. What you say makes a lot of sense, but Commissioner Gilman also brings up a good point about, sightseeing being a discretionary type of service. So coming back to the case at hand, as I said last week, and, Mr. Acera recommended that I kind of recount, what I said last week, so I will. I, in general, don't like to disagree with ALJ decisions unless I feel fundamentally that there was some points missed. And I really still feel that we didn't place enough emphasis on the letters of support that had been submitted. And I just call back to, some of the statements where Salvage Spectrum says that tour operators are turning away business due to a lack of vehicles. Palisade River Retreat says services are booked more often than not. Just the fact that Mesa County is now seeing over 1 million visitors a year. And, the testimony from Steve Talbot especially is compelling to me because he's the guy that is on the ground running the agritourism businesses there and understanding the dynamics of that business better than anybody I know. And so when he says that there is a definite need, I tend to respect that position. So for those reasons, I don't think we should kick this down another week. I think we need to make a decision today. And my position is we should, overturn the ALJ's decision and allow this to move forward.
Commissioner Gilman, what do you think? Do you want to try and make a decision, based on the facts of this case, and then try and explore these standard issues, legal standard issues, and sort of parse out how we think about charter versus sightseeing, versus other categories. I don't know if it's an I docket, an M docket, or a rulemaking. Where are you at versus trying to? I guess the question is for you is where are you at based on the facts in this case? Are you prepared to decide this on the facts now?
Yeah, I think we can separate these as Commissioner Gavin suggested. I think the facts of this case are clear and are complete, and the record there is closed. And I think, I tend to agree with Commissioner Gavin that I think that we can provide additional weight to the comments in those letters that I think paint a different picture than the analysis was done, that may be missing different components based on, peak visitors and things like charter vehicles just not being fully booked, because that may not be the nature of how they were booked. But I think that those letters of support certainly can be given more weight here to show that there is a need here and that the service appears to be inadequate to be meeting the requirements. And then perhaps take up as a separate matter the standard of review for the future and what any case law means and how that would impact, especially if there's any daylight between different types of common carrier services as we move forward with that standard of review.
That's two.
Well, it's just that from where I sit, it's an inappropriate standard, to apply to these fact situations. But so I'm very sympathetic to the ALJ and thought she had a well-reasoned opinion. But I suppose I can agree with Commissioner Gavin's characterization, recharacterization of the facts, and support a 3-0 decision resolving this case today. Mr. Serra, do you have any advice about how we can take up this issue in the future? Just bring it back to a weekly meeting, maybe sometime in January for further discussion. Once we've had a chance to confer with advisors and council and staff, is we and I guess we wouldn't even put it in order.
No, I don't think you need to put it in the decision. It's probably better to keep the decision focused, strictly on the application in front of you. But in terms of the larger ideas that you guys have been talking about today, yeah, I think that makes a lot of sense. You could put it on an agenda sometime in January would be fine. In the meantime, we can all work with you to get a better understanding of just the entire process here for the applicants. Are there places along the way that we could streamline things, and also looking at what we can do to possibly look at modifying the standard of the way we think about the standard as it applies to some of these carrier types.
And I guess going forward, in preparation for that January CWM, can we ask council and staff to come up with the best way of modifying the standard? And you may not agree that that's inappropriate or useful, or you may conclude we'll lose on appeal or whatever. But if you could, like, not just say we're going to lose on appeal, but if you could just, if you'd be willing to be as creative and thoughtful as possible about seeing if there's a way we can modify it under existing law. Mr. Gomez.
Yes, so let me just say that we will give you a thorough review of the law as we interpret it by statute and case law. And we will present that to you, and should you find that you believe that there is a way to navigate that, then we'll certainly listen.
And if you could just help us point to what you think might be the most promising way, even if you don't think it's ultimately viable, that would be appreciated. And if there is no viable way, that's fine. It just seems like there's a lot of gray. Commissioner Gilman, any further thoughts?
No, I think this is helpful. And look, I mean, there's a viable way if the legislature agrees with us that this may be an inappropriate way to regulate these carriers. But
I don't know that we need the legislature, but Commissioner Gavin, any final thoughts?
No, I'm fine with what we've outlined for moving forward.
Mr. Sarah, does that give you, I'm not sure we've resolved everything, but I think there's a 3-0 vote, and characterizing the facts the way Commissioner Gavin did. And is there any other pieces of this we need to resolve today?
Yes. So what I understand right now is there's a 3-0 vote that all three of you view the evidence in the record a bit differently than the ALJ did. You see the balance of the evidence switching the other way in terms of whether or not whether the applicant showed that the current service was substantially inadequate. So there's one more prong finding that you all would need to make in order to grant the application. And we can get to that. But before that, I think we do need to address some of the issues that were raised in exceptions, simply because they're not moot at this point. We do have 3 interveners here. So I can move through them fairly quickly, at least present them to you, and we'll see how much discussion the questions sort of raise. The first, I think, and largest issue is a procedural one. Palisade Trolley and its exceptions argues that all of the interveners should have been dismissed earlier in the case because they failed to file their letter of authority alongside their interventions as required by commission rule. I recommend that you all reject that argument. In the record here, the ALJ issued an interim decision that addressed this particular issue, along with some others, and that was R220238. And the long and short of it is, the 3 interveners showed up to the pre-hearing conference, and this issue was raised there. It turns out that 2 of the interveners who had not yet filed their authority letters, one had accidentally filed the wrong document in the e-filing systems, and the other one filed the wrong document. And it filed the decision granting its authority, but not the letter of authority itself. But both interveners filed their letters later that day. And as a result, all 3 interveners had correctly filed their letters of authority by April 14th, which is the extended deadline that the ALJ set. So because the commission has the authority to conduce its proceedings in the interest of justice, and here the ALJ reasonably extended the timeline for unrepresented incumbent carriers to file their letters of authority. At that point in the proceeding, no party had been prejudiced by the delay in filing, and therefore I would recommend to you that you conclude it was not an abuse of discretion for the ALJ to extend the deadline for the parties to file their letters of authority.
Commissioner Gilman?
I agree.
Commissioner Gavin?
I agree.
As do I.
The first substantive issue of the 2 that remain is Palisade Trolley's argument that the commission the ALJ erred by using a seating capacity analysis. And I think you guys are all familiar with that. You've discussed it already today. The argument there is that none of the court cases that the recommended decision cites used an unused seating capacity analysis. Therefore, it's not an appropriate analysis for the ALJ to undertake. I recommend you find that this argument is not persuasive. As we know from Durango Transportation, a 2005 Colorado Supreme Court case, the commission, when making the determination on the factual question, that is whether the public convenience and necessity demands another carrier, the commission can consider any relevant record evidence. And in this case, the incumbents provided evidence and testimony that directly addressed how much unused capacity they have. They did that to rebut the argument that they were unable to meet demand. So in that context and in this record, the evidence was proper, excuse me, and the argument was appropriate. And the ALJ and you all on banc should consider the evidence for that purpose and reject the argument.
Commissioner Goman.
I agree.
Commissioner Goman.
I agree.
As do I.
And the second to last issue here is raised in the exceptions. The argument from Palisade Trolley is that Palisade Trolley is offering trolley service rather than motor vehicle, passenger carrier transportation by motor vehicle. And therefore, it's offering a service that the other motor vehicle providers in that area cannot. The exceptions argue that when asked during the hearing, each of the incumbents responded that they could not meet a request to provide trolley service. I recommend that you reject this argument. In my view, the applicant, as the recommended decision thoughtfully points out, the applicant isn't offering traditional trolley service either. That is, a car traveling on tracks, on a fixed schedule, on a fixed route. And on this point, I think the recommended decision got it right. All of the interveners testified or crossed on the idea that what Palisade was proposing and what its applications are here is simply motor vehicle transportation and not any other type of transportation. So I'd recommend that on this point, you uphold the recommended decision and reject the argument from Palisade Trolley.
Commissioner Goman.
I agree.
Commissioner Goman.
I agree.
As do I.
Now, the third issue in the exceptions that Palisade Trolley raises is one that you've already discussed. And I think that in this instance, you've agreed to grant the exceptions on this point as to how to weight the letters of support and the other pieces of evidence in the record. So given that we've already had a robust conversation on that, I'm going to move on to the last point, which is in order to grant an application, the finding needs to be made both that the incumbent service is substantially inadequate and also that the public need demands the proposed service. And I recommend that the evidence here indicates that the public need does demand the proposed service, both to better meet the tourist demand and increase safety in the area as was testified to at the hearing and discussed in some of the evidence, as well as to meet shortfalls in current service offerings. So I'd recommend that you make that finding as well, and then I think that we'll have what we need here today.
Commissioner Goman.
I agree.
Commissioner Goman.
I agree.
As do I, and I think that could be an ABC order, Mr. Sarah, unless either you, Commissioner Goman, or Commissioner Goman would like to say it. So you can have make it an ABC order.
Will do. Thank you.
Thank you. Let's go to proceeding number 22V-0483.